Yes, Ms. Hampton.
My Lord, grateful. Before I start, just to remind you the application that's before you today. The application before you is for a mandatory injunction. And as Your Lordship quite eloquently put it, it's not American cyanamide, but it's who has the better argument, to put it loosely. And to that extent, we have in our authorities bundle furnished a report, Nottingham Building Society against Eurodynamics. My Lord,
yeah, I think I'm pretty familiar with that.
Absolutely,
Yeah.
so I'm not going to go through it at all, but just for your reference, it's at tab 14 of the authorities bundle. And the relevant passages are at pages 473 to 474. And my Lord, I'm not going to take you through it because you are probably more familiar with it than I am. But if you do need any assistance, then my little friend Mr. Patrick Dillon will and can assist you. But that is the test, not arguable case, but who has the better argument. And as a primary proposition, I submit that the claimant has failed to establish today that he has the better argument. The application, as we understood it on the papers, was premised on the fact that the claimant was seeking specific performance based on the fact that completion ought to have occurred based on the Howard Crowe report, and that it was binding and that it was accurate. It was binding on the defendant and that it was accurate. And again, just for your reference, my Lordship, can I take you to the claimant's particulars of claim? It's volume 1, paragraph 44.
Volume 1, divider.
Volume 1 of the bundle, documents bundle, yes?
Divider.
Divider 6.
6.
Yes.
Okay.
Page
Yes.
23, and it's paragraph 44. And this is under the title of the claimant demands completion. And paragraph 44, if I can take you halfway through that paragraph.
So did you say 44 or 24?
44.
Thank you, I got it. Yeah.
Halfway through,
Yeah.
where it starts, the Paul and Hassan instruction was not intended to lead to a report replacing the Howard report, and the claimant's consent to Paul and Hassan's involvement was made without prejudice to his position. And this is the important bit, that the Howard report was accurate and binding on the defendant, and that, until very late this morning, has been the claimant's foundation on which he seeks an injunction from this court and seeks the relief sought under his application notice. And my Lord, as you quite rightly pointed out, there is nothing in this agreement that says the purchaser's assessment is binding on the seller. And so, my Lord, what is it that you have to deal with today? There are two questions before the court today, we say, and both rest on the construction of the SPA and whether or not the following has occurred. Number one, whether under the SPA there needs to be an agreement between the parties in relation to any adjusted purchase price, or put differently, whether it's for the claimant to unilaterally decide what the purchase price ought to be based on the Howard Crowe report, and whether or not that report is binding on the defendants. The second question we say is this: if you conclude on analysis of the SPA and a proper construction of the SPA that the claimant cannot unilaterally impose a revised purchase price on the claimant, then what, if any, are the remedies available to the claimant today? And therefore, can the claimant succeed on its application? Now, my Lord, the agenda for my submissions, just so that you know, and it's open obviously to any other matter you might want me to address you on, but the agenda is this. When tackling those two questions, firstly, I intend to go through the SPA and analyse the various clauses and how they ought to be interpreted in our submission. And number two, then go on to address the claimant's submissions as to the various orders sought and what it says why you should allow this application. And if there's anything other than I've omitted to address you, or then my learned friend will correct me and stand up and address you. And that's Mr. Patrick Dillon Malone to my right. So, my Lord, whilst I'm sure it's been very interesting for you to go through the various documents and the various emails, we say this application stands or falls on an analysis of the SPA and on a true construction of the SPA. And so, my Lord, if I can invite you to turn up the SPA, that's volume 1. Now, the first time you see it is annexed to the claimant's witness statement, so it's behind tab 8.
Yeah, I've got a separate copy of it.
Yeah, I might just pull my copy out, in fact. And my Lord, just as a side point before I go into the heart of this agreement, you will have read that this document was in fact drafted by the claimant's lawyers, and therefore we say that Article 54 of the contract law would apply. And just to bring that up, that is the sort of, it mirrors the contra preferential rule in English law, but Article 57, if I may just read it out, unless, my Lord, you want to be taken to it specifically.
I can't remember off the top of my head. I've probably seen it. Article 57, then. Yeah, that's implied obligations, no?
No, sorry, Article 54, interpretation against the party responsible. If contract terms supplied by one party are unclear, an interpretation against the party is preferred.
Yeah.
So we would say that's applicable, and that should be at the, well, it is at the forefront of my submissions going into the SPA. So, my Lord, the first page, non-controversial, who the parties are, and their identities and so forth. Turning then, my Lord, to the second page of this agreement, page 106, clause 1.1. And, my Lord, we say that this clause dominates the entire contract. And the first 3 lines, in fact, set out clearly what's supposed to happen, what this contract is about. And we say it has 3 components. The first component is this, and if I can just quickly read it out. Subject to the terms and conditions hereof, and in consideration of the purchase price, as defined in clause 2 below, the sellers agree to sell to the purchaser, and the purchaser agrees to purchase from the sellers the shares and assets of the company. So that has 3 components. That the first component is this, that the consideration for this transaction is the purchase price. Therefore, if no purchase price is paid, or it's not paid in full, such purchase price being defined in clause 2 below, then this transaction, we say, is doomed to fail and no relief can be given. The second component is this. The fundamental requirement of clause 1.1 is that the sellers agree, or rather the seller's agreement to sell, is that the seller gets the consideration in full. Such consideration set out 2.1. The third component of clause 1.1 is that the purchaser has agreed, by executing this document, to pay a purchase price as defined by clause 2.1, the 10.5 million. Therefore, we say there is no other basis upon which the claimant can claim ownership of the business, save for payment of the purchase price. So there's no basis upon which the claimant can come to the court and say, transfer the shares over to me, I'm entitled to this business. Simply put, if he hasn't paid the purchase price, then there is no entitlement there. Clause 1.2, my learned friend referred to this. If I understand his submissions correctly, the pertinent aspect of this clause is that there is a cut-off date, namely that after the 31st of December 2015, all liabilities and all benefit will be for the claimant. Now, I didn't quite understand the point of that submission. However, if my learned friend is saying, well, look, the claimant is entitled to this business because after this date, December 2015, then any liability incurred by the business will be his. Again, that's not entirely true in terms of the way that businesses work in Dubai. There is no liability to him personally, firstly. Secondly, the liability is to the company. Thirdly, if there is any individual liability to be attached to a person, and not the company, then that liability arises out of the person who's on the trade license. The claimant is not on the trade license, and therefore there is no relevance to that cut-off date. Turning then, my Lord, to clause 2. So this is the clause that tells us what the purchase price is. The total sale purchase consideration payable by the purchaser to the sellers for the shares and the assets of the company, as per clause 1 above, which I've already referred to, shall be 10.5 million dirhams, and then defined the purchase price. At the request of the sellers, the purchaser has paid and agreed to pay the purchase price in the following manner. So under the constraints of this agreement, this payment plan that you see is how payment was to be effected. And my Lord, you've already made some very valid points in relation to this payment plan. And just to pick up on some of the points made. Firstly, 2.1. This is the value that the seller puts on the business when he executed the SPA. Therefore, the key feature of this SPA, which has been defined and which is certain, where there is no ambiguity, is that reading clause 1.1 with 2.1, that 10.5 million is the consideration, is the purchase price to be paid for the acquisition of this business. Turning then to the payment schedule. So there's no dispute. Payment 1, payment 2, payment 3 was paid. So that's 3 million. However, and again a matter that I will be referring to later in my submissions, that 3 million has been recouped by the claimant. But that comes later. Again, coming back to this agreement, payment 4, upon completion of satisfactory due diligence by the purchaser. Now, it's not quite clear from the claimant's submissions and from all the documents as to whether or not there has been satisfactory due diligence. If there had been satisfactory due diligence, under this agreement, the claimant was obliged to pay 2 million. He's not done so, and therefore, that in itself would demonstrate or create an inference that the due diligence was not satisfactory. If there has been satisfactory due diligence, or rather, sorry, the further points that lead to the conclusion that the due diligence wasn't satisfactory is because we hear time and time again the complaints about the process, the due diligence process. There was non-cooperation, there was failure to provide documents, there was failure to clarify aspects of the report, and therefore, my Lord, the due diligence was not satisfactory. And we say that has an impact on the rest of the clauses going forward. If I can perhaps also touch upon this point, the 2 million, again, there's a dispute as to whether or not monies received by the defendants were towards the purchase price. We say no. The basic and simple point is this, that 2 million has not been paid. Any monies that may have been given to the company were not under this SPA. 2 payments, and very quickly I want to deal with this point. 2 payments, one for 750,000. That was an internal transfer within the business, and the 500,000 was against supply of stock. So, not under this SPA, a completely different claim, and that claim can be made outside of the provisions of this SPA by the claimant. Perhaps, in relation to the payments made. And again, I just want to turn to the Paul and Hassan report, because my learned friend looked at this to say that payments had been made. Actually, my lord, I'm going to turn to Paul and Hassan later. Let's not go away from the train of thought. Payment 5. The balance amount shall be paid in 6 equal instalments, 5.5. We say it's at this point that any deductions were to be made. But that's not deductions decided by the claimant unilaterally. Those are deductions arising by way of an agreement between the parties. That's what we say. Clause 2.2. Now, my learned friend says that this clause obliges various things to happen once payment 1 and payment 2 and payment 3 has been made. And reading payment 1, payment 2 is the transfer of the vehicles free from any encumbrances, number 1. Number 2, payment 3, assign all the trademarks. It's the defendant's position in relation to, and I'm going to take trademarks first, it's the defendant's position that the trademarks have been assigned. The claimant says that's not right because we don't know. Again, going back to when this agreement was executed, it was the claimant's lawyers who drafted it. The defendant's position is that when they handed over these annexures to the to the claimant's lawyers, it was for the claimant's lawyers to attach them to the agreement. So therefore, having carriage of drafting that agreement, they did have it. Number 3, in any event, following your order when we were last before you, I think it was the 10th of September, following the 10th of September order, you ordered the defendant to provide an accurate picture as to the trademarks. We have now done that. And so, my lord, there ought to be no dispute in relation to whether or not the trademarks have been assigned over. We say yes, they have. And actually, it's for the claimant to reassign the trademarks to us, given the breakdown of this agreement. But in any event, in accordance with 2.2, trademarks were assigned. Payment 1 and 2 relates to the transfer and ownership of the vehicles. Now, my learned friend, again, it's not clear what he says as to why there is a dispute. However, we say that we provided a list of all the vehicles, and we did that with a letter of intent that was signed prior to execution of the SPA. And if I could just perhaps very quickly take you to this letter of intent, it's volume 2, tab 20, and it's page 558. And it's the fourth paragraph where we see this. Whereas the first instalment has been paid to seller by buyer, 2 million. VDA checks 40404041, each of 1 million of Aviv Bank, against Hayaza and stroke transfer of all 56 vehicles owned by company, those cleared from bank and listing closed to buyer with immediate effect. Next instalment of 3 million will be paid to seller by buyer by end of December 2015, and so forth. So that's really setting out the mechanism. But the point...
So I have no idea what this document is. As I understand it, what we were looking at, and maybe I misunderstood, was the provision in Article 2.3 of the agreement.
Yes.
That the $2 million dirhams, was in relation, you said, to the vehicles, but in fact the agreement refers to the shares.
Yes, well, I am going to go to that point, but if I just deal with 2.2, if you look at 2.2, company sellers confirms that it's received payment 1 and payment 2 mentioned above and obliged to transfer the ownership of all vehicles. So payment 1 and payment 2 was for all vehicles, and that's at 2.2.
Sorry, 2.2 of what?
Clause 2.2 of the SPA. So page 3. Page 3 of the agreement.
Oh, I see. Your payment is now obliged to transfer the vehicles, right?
Yes.
Follow that.
So that's payment 1 and payment 2.
Payment 1 and payment 2.
Yes.
But then 2.3a
Yes.
is odd because that seems to refer to the shares.
Yes, and so we say that there is a mistake there.
There's a mistake.
Because it wasn't supposed to be shares. It was at all times intended by the parties that the vehicles would be transferred following payment 1 and payment 2.
Well, now, I understand that point, and you say, perhaps in due course we may seek rectification. But now then we looked at page 558 in volume
Yes.
2. Now I don't know what this document is.
Right. Well, let me take a step back. In relation to clause 2.2, as I understood my learned friend submissions, and I may have got it completely wrong, appearing before you on about 2 hours sleep, is that this did not happen. The transfer of vehicles didn't happen. Because, and even if it did, they don't know whether or not it's the entirety of the suite of vehicles. And what I'm saying, and it's a very small and minor point and may not go to anything, but what I am saying is that at all times the claimants knew the vehicles that were owned by the company, and therefore it's easily ascertainable what the vehicles are. That's my first point. And the reason why it's ascertainable is because of this letter of intent at page 558 that was signed prior to the execution of the SPA. And we see there behind it a list of vehicles.
Yeah.
So that's my first point, addressing my learned friend's argument that we don't know whether or not this has happened. The second point is this. My learned friend puts the culpability of not transferring these vehicles at the defendant's door, but that's not right. What in fact happened was that the defendant attempted to transfer these vehicles, 56 vehicles, to the claimant. However, they received an objection from the RTA, the Road Transport Authority, to say that because these vehicles were registered under a company's name, they could not be transferred over to the individual. They had to stay with the company or under the company. Yes, the purpose of the vehicles remained for the company, and that's the reason why there was an objection by the authorities that they could not be transferred. And then finally, my learned friend says that there is property that they don't know about when we say, well, there isn't. The only property is the business premises, and that's simply it. So,
well, then how does the contract work? You say that clause 2.3a is inaccurately drafted. It should refer to the
vehicles,
not the
yes.
shares. And that, therefore, what was originally prescribed, and this is an agreement dated
8th of February 2016.
In 2016.
Yes.
That in the event of a failure to transfer the vehicles, then this cheque is to be a guarantee, correct?
Yes, correct.
But if you now say, and I understand the point, that transfer was not possible because of the RTA objection.
Yes.
So what actually happened?
Well, the vehicles remained in the ownership of in the company's name. So the company, yes. So the company.
But available, so they couldn't be transferred to the purchaser.
Yes.
Although I suppose it could be transferred to a nominee. I don't know.
Well, it was the authorities that said because they're.
Where you say that, in effect, the guarantee cheque had no further purpose because the vehicles couldn't be transferred, but they were available to the company.
Yes, absolutely.
And that was a company that was at least going to be purchased by the buyer.
Absolutely, that's precisely the point. And so.
Thank you.
So 2.3, we've just dealt with. 2.4. So, my lord, this is really the crux, it appears, from the claimant's submissions, where the bone of contention lies. I pointed out the pleaded case, and as I said, we understand that what the claimant is saying, that the Howarth-Crowe report was binding, and it was binding because of this clause 2.4. And I take that as well from the claimant's skeleton argument, and in particular, paragraph 26.2. So, just in terms of dissecting this clause then, what does it actually say? Payment for, as mentioned in the above schedule, shall be made upon completion of due diligence procedure duly started by the purchaser to his satisfaction. The claimant appears to be clutching onto the words to his satisfaction to advance an argument, it would appear, that the assessment by Howarth-Crowe of what the value of the company is ought to be binding on the defendant because that's to his satisfaction.
And that's not what the claimant is saying.
I didn't hear what you were saying.
That's not what the claimant is saying.
Well, I thought that, well, if it isn't, at least as I understand it, it's clear from the pleading that you are insisting that the figure that emerged from the due diligence exercise was a figure binding on the parties.
No, that's not correct. I don't want to interrupt my learned friend, but...
Well, I'm not interrupting her. I just want to know what you are saying.
Yes.
She drew my attention to the paragraph.
One needs to look at paragraph 49 of the particulars of claim.
I mean, it was certainly what I thought was being said, but I misunderstood.
My Lord.
Hang on, let me just see that something. So I've now lost the paragraph you showed me.
49.
49. 44 you showed me.
Oh, I showed you, yes, I beg your pardon. I showed you 44, page 23.
Yes, that seemed to me what I thought was the argument that was being made, that the Howarth report was binding on the defendant.
No, 49 goes on to say the claimant sought to engage the first and second defendants.
Hang on, let me look at 49. Well, no, I'm looking at 44.
Yes.
I don't think 49 deals with this point at all. What 44 is dealing with is the question of the materiality of the Howarth report. And the materiality, according to the pleading, is that the conclusion of the Haworth report was accurate and binding.
Well, what the claimant was actually what the claimant was saying, and this is in his evidence. So this merely reflects his evidence. Was that he had the Haworth report?
No, come on.
Yes.
It's that what is being pleaded.
Yes.
That the claimant's consent, for what it's worth,
yes,
to Paul and Hassan's involvement was made without prejudice to his position, i.e. his case, that the Haworth report was accurate and binding.
That's right. That was his.
Well, I think that's what Ms. Ahmed is saying.
Yes.
What's wrong with my analysis?
Because in fact, and the way we put it today, and the way when you look at clause 60. 60 of the particulars of claim.
Well, that's the alternative to your specific performance claim. I follow that.
Yes,
but your primary case, it remains that the figure of 91,000 is binding on the.
But it's not. But to be clear, and maybe it isn't clear enough. But
it's more than clear. It's absolutely stark clear.
The 91,000 was considered to be binding as a figure, but it's not simply because Haworth produced a report. It's because it was an accurate figure. That's what the claimant's position was.
No, come on, that's pure casuistry.
Well,
Paragraph 44
yes.
it makes it plain that the claimant's position, i.e.
Yes.
his case, is that the Hall's report was accurate, fine, and binding on the defendants for due diligence and completion purposes. I.e., I read that as meaning that it was your case, and I think I raised this right at the beginning, that the 91,000 was the figure that your client was saying he was prepared to pay, having exercised due diligence, and that the defendants had to accept it.
But that's not that. Let me break it down, because this is correct and accurate. That the claimant was saying that the Horwath report is binding,
Right.
but he didn't say this is a take it or leave it, and that's made clear by 49. And also the correspondence that I took you to today. What he was saying was, to the extent that you don't think that the Horwath report is accurate, get your own report and then let's talk about the figures. And that's what 49 says.
Well,
and that's
all right. I accept that you might put an alternative case that the figure was prima facie binding unless the defendant successfully challenged it.
That's
Is
right.
that what
Yes, I think that's a fair
Well,
point.
all right.
And that's why 60.
I don't think that's what your client was saying in the correspondence, but my reading of the correspondence is absolutely clear that your client was saying, I want these shares transferred, and I'm offering you 91,000. I don't think he's ever suggested for one moment that he was considering paying more than that.
But what is clear, again, without taking you back to the correspondence, what it was clear that he was asking for a meeting to go through the figures.
Well, there we are.
Without that meeting taking place, we can't know how much flexibility he would have.
But I don't see anything in paragraph 49 of the particulars of claim which affect that impression, if I put it no more than that.
I mean, 50 is relevant as well, and this again comes directly from the claimant's evidence. What he says is that then he discovers later on that there were further liabilities.
Well, there were further liabilities,
Yes.
i.e. the 91,000 was too much.
Yes.
Right. In the premises, there was no further amount in respect to the purchase price owing to the defendants.
And that's what he's
Full
saying.
stop.
Full stop.
Claimant
But
continues-
alternatively, if he's wrong about that, he will, as I said at the outset, he will pay whatever the court decides.
That was the primary case, as I
Yes.
understand it.
Yes.
And I don't think you're quibbling with it.
I'm not quibbling.
Yeah.
And then reading on paragraph 50, the claimant continued to demand that the defendants complete the transaction and transfer the shares. And so, my Lord, my understanding of the claimant's case accords with yours in that the claimant was demanding completion on the basis of Howard Crew's assessment that the only extra monies that ought to be paid for acquisition of this business is 91,000. And so, going back to clause 2.4 of the...
Well, indeed, in the skeleton argument, it says the claimant was, of course, entitled to seek completion based on the Howard's report.
Yes. And in fact, even the submission was made before Sir Justice Field on the 27th of August that consideration had been paid, and so that leads into...
So where do we see that?
That's in the transcript, my Lord.
Oh, I see, I'm sorry.
Yes, I'm not going to bother you going through the transcript.
I think I can be spared looking at the transcript.
Well, I'm hopefully going to spare you going through the details of the email correspondence. You clearly have read them.
Yeah, anyway, let's move on to something that was a little more controversial.
But 2.4?
The point that's raised on 2.4 is that, as I understand it, that in the... Well, let me start at the beginning. You express surprise, which I have to confess I slightly share, and that the claimant was satisfied with the due diligence exercise given the circumstances in which he makes complaints of lack of cooperation, documentation, etc., etc.
Yes.
But anyway, let's take it that he was satisfied. How does it work if he's not satisfied, what happens? They say there's an option. He can either get his money back, or you can continue to comply with the terms of the contract. Now, is that right or not?
Well, can I just break 2.4 down to help me more than anything? And then I will address your question. We say that 2.4 is made up of 3 different parts. The first part is, as provided for in the first sentence, payment for, as mentioned in the above schedule, shall be made upon completion of due diligence procedure duly started by the purchaser to his satisfaction. So it talks about a due diligence procedure, started, completion. At that point, once that due diligence procedure is completed, so once the claimant was in receipt of the Haworth Crowe report, irrespective of what the findings were, once he was in receipt, payment for ought to have been made, and it wasn't, and therefore there's been non-compliance by the by the claimant. And the only reason for that non-compliance could be non-satisfaction. Then the second part of clause 2.4 reads as follows: the parties agree and confirm that they shall fully cooperate with the purchaser and provide him or his representative all such documents, information required for the purposes of carrying out such due diligence, and permits the purchaser to advertise the sale purchase of the share and assets of the company in any newspaper in UAE, and shall not conceal any data information which would affect the judgment of the purchaser with respect to trading assets, rights, obligations, liabilities of the company shares, the due diligence. So the second part of clause 2.4 defines what due diligence is, and we say that the due diligence is the sharing of information or the provision of information by the defendant so that it assists the claimant to assess what the value of the company is. Nothing within these 2 sections or parts then imposes an obligation that the claimant can unilaterally vary the purchase price. It's just a process.
Okay, so assume that there is, in one sense, an option. He can either takes what he gets, whoever report, and he decides it's not good enough, or there hasn't been proper cooperation, so he pulls the plug on the whole exercise.
Yes,
that is explained. Assume that for some reason or other he decides he won't pull the plug on the exercise, and he's going to go on. And assume, for the purposes of my question, that the first obligation he's under is to pay 2 million, payment for. What happens if he doesn't pay payment for?
Well, there's no satisfaction, and therefore if there's no satisfaction, then that's the next part. Within 7 days, he ought to
but I think that's referring to this return of the 3 million.
Yeah, well, in 7 days he ought to make a written demand for return of the 3 million, because at that point the agreement breaks down. There is no point going forward with this agreement.
That's really an answer to my question. Okay, I understand. Well, let's move on to the next question.
Yes.
Much of the thrust of your opponent's argument was directed at the second sentence of paragraph or article 2.5. Help me with that.
My Lord, can I just a small indulgence and deal with the rest of paragraph 2.4?
Okay, sure.
So in terms of, it's going back to the satisfaction. If the claimant was satisfied, then he ought to have made the payment of 2 million, payment for. The fact that he didn't make that payment could potentially amount to a repudiatory breach of the contract, which would entitle the defendant to terminate. So that would be the first effect.
Well, you may be right about that, but I'm not sure you've said so.
Well, it didn't happen. The second effect is that there is a mechanism provided by 2.4 which allows the claimant return of his money on written demand. What he's not entitled to do under 2.4 is go and cash the cheques. And again, my Lord, I've heard what you've got to say. And we say the reason why he did that was simply to put pressure on the defendants to transfer the business. and as a side, the transfer, or rather the pressure, wasn't just that, but it was also Pharmex issuing...
What you say, as I understand, he should return them.
He should have returned them, absolutely. Yeah. Number one, it happened. He should have returned them. And number two, there was no entitlement for him to cash the cheques because there was no trigger. And thirdly, the only reason why he didn't return them, why he cashed them, was to put utmost pressure on the defendants to transfer the business. And this wasn't the only occasion whereby the Dubai courts were approached. You've heard about Pharmex. We say Pharmex is a direct competitor. Pharmex then instituted numerous Dubai court criminal proceedings, and those are referred to in the defendant's witness statement. And my lord, can I just take 1 minute to take you there, please? It's in volume 2, tab 20.
Hang on a minute. In volume 2.
Tab 20.
Yeah.
And it's page 521.
521.
Yes.
Thank you.
So you may ask what relevance is Pharmex in this proceedings. We say a lot. Pharmex is owned by the brother of the claimant, firstly. Secondly, it's Pharmex who instructed Howard Crowe to produce the report. And the reason why Howard Crowe was instructed was to acquire the defendant's business, because it would be an attractive bolt-on to Pharmex. It would allow Pharmex to go into the retail segment of the market. And I don't want to jump around, but I take that from the Howard Crowe report itself.
Well, interesting. I mean, you may well be right that Pharmex are cooperating with an associate company or the claimant's associates, I don't know. But it's the claimant who files the criminal complaints in May, isn't it?
It is the claimant.
June, yeah.
Yes, it is.
I agree earlier, Pharmex had done so in March, but the main thrust comes from the claimant claims.
Yeah. My lord, have I referred you to page 521? I thought I took you there. Volume 2.
Yeah, I got it, 521, yeah.
Page 521, yes.
That's in April.
Yes, well, the table there shows all the details of when Pharmex instituted criminal proceedings or attempted to against the defendant. And so the submission made by my learned friend, well, it was a mistake, it was only a one-off. We say, well, it wasn't necessarily a one-off. There was an absolute campaign that the defendants were subjected to of harassment and the threat of legal proceedings that came from the claimant and his brother.
Understood.
Now, going back to, again, the SPA, and you pointed me to clause 2.4 of the SPA, 2.5 rather. Now, my learned friend relies on this clause to say, well, and it's the second part, the parties also agree that upon execution of this arrangement, the purchaser shall be entitled to nominate its representative to singly manage the affairs of the company till such time the transfer of the shares is not effected due to the unsatisfactory due diligence. Now, I'm going to pause there. My learned friend is attempting to persuade this court that the reason why the claimant ought to be let back into the company is because clause 2.5 entitles him to do so on execution of this agreement. We say that that's the wrong interpretation, and the reason why is because of the words, till such time the transfer of the shares is not effected due to unsatisfactory due diligence. And that's where we are at this point. There has been, we say, unsatisfactory due diligence, even on the claimant's account and the claimant's case. And therefore, it can't be right that this clause intended for the claimant to manage the company, even where there had been a complete breakdown of the relationship, an irretrievable breakdown of the relationship, irreconcilable differences, There is no way that this clause would have intended for the claimant to manage the company under those circumstances. And therefore, my Lord, we say that you ought not to grant the relief asked for.
Okay.
And we say the same for 2.7. It cannot have been intended for this agreement to operate in the way that's been suggested by the defendant. Sorry, the claimant. And just
well, you say implicit in that, I assume you say that this agreement to include the purchaser as a signatory would not survive. Well, it wouldn't survive termination of the agreement. It wouldn't survive termination of the agreement in accordance with 2.4. And you say that the reality of the position is that there hasn't been satisfactory due diligence, and that must not implicitly terminate any need for somebody to be an extra signatory.
Absolutely, my Lord. That's exactly what I'm saying. And the reality...
But what's the position if there has been satisfactory due diligence, despite the fact that, assume for the purposes of argument, although I'm finding it difficult to make the assumption that the claimant thinks it's all very satisfactory, everything has been fine, and therefore he's prepared to accept this company and the completion of the purchase. You need to establish, don't you, that the contract has come to an end.
Well, absolutely, and that would be my
and
point.
Your primary case there is, as I understand it, failure to pay instalment number 4, and what?
And it's
going to the police.
Absolutely. Well, it
going
says,
to the Dubai courts.
Yes, we rely on a number of breaches.
Failure to return the checks, which is the same thing, I suppose.
Yeah, yes, my Lord. We rely on a number of breaches as set out in our defence and counterclaim.
Yeah.
If I may just invite you to
Of
turn
course.
up the defence and counterclaim. It is at volume 3.
Yeah. Well, 3, right?
I beg your pardon, let me just...
I think it's a bit on.
Volume 2, I beg your pardon, tab 19.
Thank you.
So it's at tab 19, page 492.
Yeah. Yeah.
We say that we set out the particulars of the repudiatory breaches that we seek to rely on.
Not sure I'm understanding D. That's what, failure to comply with 2.4 or something?
Yes, the 2.4.
Thank you, I've read that. No, I haven't finished. Yeah, okay.
And so, my Lord, in response, there is no way that it would have been envisaged that on termination of this agreement that these provisions were extant or would remain alive.
Yes, thank you.
And my Lord, just to add, and I know you've got the point, but just to add further as to this idea that there has been, on the claimant's case, satisfactory completion, we say that, again, looking at the reality, payment for hasn't been made and therefore there can't be any completion. And in any event, my learned friend has pleaded in his particulars that the process of due diligence was not satisfactory. And again, if I may just very quickly...
Where do you say that?
Well, I'll take you to that. It's volume 1, tab 6.
Yeah.
Page 26, and paragraph 58.
Thank you.
By the action set out at paragraphs 30 to 55 above, the defendants have also breached the warranties contained in the SPA, in particular warranties in relation to the accuracy of the information provided, company liabilities and cooperation, and or caused damage and created liabilities. And the warranties relate to the provision of information.
Mm-hmm.
And therefore the only inference that can be drawn from that paragraph is that there has been no satisfactory completion. I mean, what appears to be happening here is the claimant isn't really pinning his colours to the mast. He wants his cake and he wants to eat it. But we say that for the relief that is being sought today, he simply can't do that and he cannot go that far.
Yeah.
And then my learned friend appears to be relying on 2.7, and again it's the same submission. And so we say, in relation to the claimant's primary case, that the Haworth Crowe assessment could not have been binding, and nor was it intended to be binding pursuant to this SPA. And we say that for 3 reasons. So there's 3 propositions upon which I base my submission. The first one is this, that there are express obligations under the SPA that can lead to only one conclusion, and that is that any variation to the purchase price had to be agreed. And why do I say that? Because there is a provision in the SPA, my Lord, if I can just take you to that. Page 9 of the SPA, and that's clause 7, dealing with entire agreement.
Where does that go?
Whereby it's a term of this agreement, it's the second part of the clause. This agreement may not be amended or modified in any respect except by written instrument signed by the parties hereto. And therefore we say that that's an express provision that places an obligation on the parties that any variation to the purchase price can only be by way of a written instrument.
I noted in passing that there was a reference, I think, in your scholarship to the fact that earlier the claimants had been relying on clause 6. I'm not sure I remember that.
My Lord, they relied on clause 6 in the particulars, and also before in the hearing before Mr. Sir Justice Field, and I'm being told before you on the first occasion, that in relation to their reliance on clause 6, if we go back to the particulars, it's volume 1,
Yes.
tab
Yes, tab 6.
Tab 6, page 17,
Yes.
clause 9,
Yes.
sets out the clause, and paragraph 10, it follows from clause 6 that the claimant was entitled to request completion at any point following execution of the SPA.
Yes. Yes.
Now, that cannot be right, and we say it's not. And in fact, my learned friend was pulled up by Justice Sir Richard Field on the 21st of August 2017. And very quickly, because we are on the bundle, behind tab 7, very quickly, it's a transcript.
Yeah.
And in particular, it starts page 42 at the bottom.
Yeah.
Representative from section 5, page 9 of the indemnification. Sorry, page 43.
Yeah.
Then you have section 6, additional documents. This clause is interesting or important because it suggests that the transfer could take place even prior to the payment of the consideration, it says, and so forth. And Justice Sir Richard Field then says, I'm not overwhelmed by the legal analysis that leads to the outcome.
Yeah. Okay.
And as we point out in our skeleton argument, it's an administrative obligation after everything has been agreed, after there's been agreement in relation relation to the purchase price.
Yeah.
So that's the additional documents. And so, as I said, there are express obligations in this SPA, which leads to the only conclusion that any varied purchase price had to be agreed. The second point in relation to agreement of a varied purchase price is by looking at the conduct of the parties.
So what issue are we on now?
As to the agreement to the varied purchase price. Should the parties...
Well, I don't think anybody's suggesting there was an agreement to vary the purchase price.
Well, my lord, the claimant wanted to impose a varied purchase price.
Maybe so.
Yes.
But I'm saying there is no evidence, and I don't understand anybody to be asserting that the parties were ad idem.
No, they
by way of an amendment to the purchase price.
They no, certainly were not, and we say that they had to be in agreement if the claimant wanted to rely on a revised purchase price.
Well, again, I think you may be pushing an open door there.
Okay, I shall move on. And so, my lord, that deals with the provisions of the SPA that I was going to take you to. Apart from clause 5, clause 5 is important, we say, and that's at page 9 of the agreement. In the event sellers breach or is deemed to have breached any of the representations and warranties, or fails to perform or comply with any of the covenants under this agreement, sellers shall refund, inter alia subject to the other terms of this agreement, all payments made by the purchaser, and compensate and hold harmless, indemnify and defend the purchaser or his nominee and each of his directors, officers, shareholders and so forth from and against any losses suffered, damages incurred. And why do we say this is important? Well, my lord, it's important in the sense that it's relevant at this point to inquire as to what, in fact, has been paid. It's accepted that initially 3 million had been paid. However, and that was under the payment plan, payments 1, 2 and 3. However, we say that that 3 million has now been recouped by the claimant through the actions in the Dubai courts. So that's no longer available towards the purchase price. And so the effect of any order that you make, you say, is that, in effect, the claimant will acquire this business having paid 0 consideration.
I'll have to understand that. You rightly say that as a result of the proceedings in Dubai courts, 3 million has been put up by way of security, as I understand.
Well, no, my lord, I go further than that.
Oh, right.
3 million was paid into the Dubai courts, and as I understand, that is then there for the benefit of the claimant, and so it's been paid. I mean, that's we have our local lawyers sat behind us, and that
I.e. that. I mean, if they terminate
so the
let me understand how this works. There were proceedings in the Dubai courts
yes.
in which the checks were sued on.
Yes.
3 million was paid into court.
Yes.
So what? If all they have to do is withdraw the proceedings, and they'll get their 3 million.
Yes.
Right.
In effect,
I understand
yes,
that.
that's right.
So you're saying effectively,
yes,
the 3 million referred to in paragraph 2.4, clause 2.4, has been duly reimbursed to the purchaser.
Yes, my lord. Yes.
And therefore, have I misunderstood?
I'm told it's even more drastic. In effect, they can turn up at court, withdraw the 3 million, but it doesn't necessarily mean that they withdraw the proceedings. And I suppose...
Well, presumably it's security for the claim. If the claim is there, the security has to remain. If the claim is withdrawn, they can take the money away.
It's not security.
It is a payment. It's the invoice to the court. It's something to the right court. Check this is showing the invoice. As based on that case, which because it had been before.
Yes. So my understanding is of how it works is that effectively, because it's a criminal case,
Yes.
then it doesn't necessarily need withdrawal of the proceedings because it's been brought by the state, presumably.
Right.
However, they can get that the money that's paid in is in effect
Is available.
Is available, and it's for the benefit of the claimant. So the claimant could go withdraw the money.
Well, the only relevance, I don't think we need to go into too much detail. You're saying
There's
that
been no
the
consideration.
return of the 3 million has effectively been affected.
It's been affected, and also there's no, then, if that's correct, there is no consideration by the claimant to acquire this business. And so therefore, if you were to make an order
Well,
of...
you're saying it's implicit in the proceedings, well, that they are, in fact, exercising the termination provisions of 2.4,
That's
because
right.
otherwise there's no purpose in the exercise.
Yes,
Okay.
yes. So therefore, it's two. The effect is twofold, as you say. They've evinced an intention to terminate the contract, and therefore they cannot now go to court and seek the orders that they do. And secondly, there has been no consideration paid whatsoever under the SPA, given they've recouped the money. And again, that goes back to whether or not you ought to make these orders, and we would dissuade you from doing so.
Mm-hmm.
So, my Lord, I'm just checking my notes in terms of what else needs to be dealt with. My Lord, I've dealt with termination. Would you like me to address you any further on termination?
No, I don't draw any conclusion of that. I'm not sort of feeling you've not covered some ground I need help on.
Yes.
So you've dealt with termination.
I've dealt with the clauses of the contract.
No.
I've dealt with termination and the effect thereof.
Right.
Damages being an adequate remedy.
Yes, you've got to deal with that.
Yes.
Okay.
Yes, so moving very quickly, damages being an adequate remedy. The claimant's skeleton argument deals with this at paragraphs 27 to 29, and that's page 8 of his skeleton argument.
Yes.
We say damages would be an adequate remedy, and we say even the SPA contemplates damages to be an adequate remedy by way of clause 5, which I've just pointed out to you. So therefore, if there was a breach of any obligation under this agreement by the defendant, the claimant could, under clause 5, seek compensation for any losses suffered and damages incurred.
Yeah.
What the claimant hasn't properly set out is the basis upon which he says that these damages aren't easily quantifiable. Firstly, we say that the measure, it's not whether the court can measure the damages, that's not the test. The test is whether or not it's an adequate remedy. And we say that the court, and in response, that the claimant hasn't identified and proved that damages wouldn't be an adequate remedy, firstly. And secondly, we say that this court is perfectly capable of assessing damages in the event that you don't grant the orders. One of my learned friends' submissions was that, well, it would be difficult for the court to assess what the loss is to the claimant if he wasn't managing the company. We say that the courts up and down all over the world make those sorts of assessments based on a loss of profits type claim, and therefore it would be for the claimant to adduce the evidence, and the court could well, or it would be well within the remit of this court to quantify the damages, and therefore we say it just doesn't make sense to say that damages would not be an adequate remedy insofar that it is provided for within the SPA.
Thank you. Right, now...
Now, the only other point then remains is the appointment of the receiver.
yes.
If you need further submissions on this, I'm going to allow my learned friend, Mr. Malone, to deal with this. However, our point on this is very simple. The appointment of receiver or the right to appoint a receiver derives from the RDC, and it's 49.3. And the court's power to appoint a receiver are set out in those various laws of the DIFC. Now, the first point is very simple. That is that the claimant has failed to argue any case whatsoever or any submission. There is no submission before you that recognises any sort of trigger in relation to appointing a receiver whereby the company is in the DIFC. My learned friend has referred you to a case of the English court. And yes, that's very interesting. However, we say that English case law is not the law that ought to be applied in this jurisdiction. It's simply an aid to interpretation. And therefore, the claimant has to come to court and establish a trigger for you to appoint a receiver. It's not simple. It's not good enough to come to court and say, well, actually, we're worried about the management of this company, and therefore you ought to appoint a receiver. That's not the test. The test is set out in 49.3, and we say you haven't been taken to it. There is no trigger. On the face of the skeleton argument, the claimant hasn't set out his submission as to why you ought to properly appoint a receiver. In any event, we say that this is an onshore company, and therefore any power to appoint a receiver lies under the powers of the UAE federal law, that's the company's law, not under any statutes of the DIFC law, because the DIFC law statutes are referable to those companies incorporated within the DIFC.
Yeah.
And therefore we say that the claimant has failed to point to any power of the court that allows you to trigger such a drastic reaction as to appointing a receiver.
I think it was to say some of the threshold requirements for 49, 10 and 11
Yes.
have not been complied with.
Have not been complied with, absolutely, my lord. That's the simple point.
Yeah.
And therefore, my lord, what relief can you order as a result of this application? Today, we say that you ought not to order a mandatory injunction, either compelling the claimant to manage the business, go in and manage the business, or the transfer of shares, or there being any nomination in relation to any signatory to the bank accounts. Firstly. Secondly, we say that the claimant hasn't satisfied you as to why a receiver ought to be appointed. And thirdly, and I don't think you've heard much, well, you haven't heard anything on this, but there is also a continuation application before you. That is in relation to the preservation order. We say that that ought to be dismissed and that ought to not continue, although you haven't really heard anything from my learned friend in relation to that. What this case is, I mean, we say it's not as complex as the claimant would like you to believe it is. It's a simple case of construing the terms of the SPA and to conduct an inquiry as to whether or not there has been compliance with the SPA. That inquiry cannot be conducted within the remits of the application brought by the claimant. It's not for this court to conduct a mini trial. In fact, this is a case that ought to go to trial if the dispute continues. Evidence ought to be heard, cross-examined to get to the heart of the issue. It's not one where it compels this court to award a mandatory injunction. Not really on the submissions that you've heard today, particularly where the case has changed from whether or not the Howard Pro assessment is binding. As I understand, that's no longer before you today. The case before you today is whether or not you can order an injunction based on clause 2.5 and 2.7. We say no. Primarily, the agreement stands terminated. It stands terminated by way of the claimant's repudiatory breaches, which the defendant has accepted, In any event, we say that that it's terminated because of clause 2.5 and because of the return of the 3 million in effect. So, my Lord, we would say dismiss all the orders that have already been made, don't allow the application, and the claimant should be afforded, I beg your pardon, the defendant should be afforded his cost of this application, and as I understand, there ought to be a statement of cost before you, and if there isn't, I can hand one up to the bench.
Yeah.
My Lord, would you like any further assistance on the receiver point? The appointment of a receiver in terms of the case law and in terms of what the authorities say?
Well, if you have something to...
In which case I pass the baton to my learned friend, Mr. Patrick Dillon Malone.
Thank you. There are in our bundle of authorities an extensive number of authorities, and just I can assist you in relation to any of the following aspects, but it may be that you do not wish for that assistance. First of all, in relation to the test for the grant of mandatory injunction.
No, I don't need help on that.
Very good. I could bring you to the relevant statutory provisions governing the power of this court to appoint a receiver on an interlocutory.
Well, as I understand, Ms. Oakland, you were saying that the relevant provisions are the relevant statutory
yes.
materials as referred to in
yes.
the rules.
Exactly.
And she said, as I understood it, that those apply to DIFC companies and DIFC companies only.
It's a little bit more nuanced than that.
Right.
It is the case.
Well, if there's a nuance, you better tell me what
yes.
it is.
First of all, there are, we say, an exhaustive, defined number of powers under DIFC law provided for by statute, which provide for the criteria according to which it is within the power of the court to appoint a receiver, including an interlocutory stay. And the first, if I could take first of all the general power of the court, is in Article 25 of the Court Law, and in the Article and in Rule 49 of the Rules of Court. Those, if I could refer you to tab 4.
Yeah. I'm looking at 49, yeah.
Yes, and tab 4, the statutory power which governs the general power of the court.
So it's tab 4 of what?
Tab 4 of the Book of Authorities.
Oh, I'm sorry. Yeah, yeah, I'm with you.
Yes, that is Article 25, which is referred to in Rule 49. The court of first instance may, by interlocutory order, and at any stage of proceedings, appoint a receiver or provisional liquidator, and it goes on to say they attach any terms and conditions to the appointment it considers appropriate, and may provide for receiver and provisional liquidator the powers of the court. Now, that provision, Article 25, is contained within Chapter 1 of Part. Excuse me, I just get my note. That's contained within Chapter 1 of Part 5 of the Court Law. And they provide for the general powers of the court, for example, to award damages, to have any powers that the court would be familiar with. But there are no criteria set out in that. That is a general power. The criteria for and the specific circumstances in which the court may appoint a receiver are set out in the other laws referred to. For example, Article 136 of the Companies Law, which is at tab 2, that provides for the appointment of a receiver in respect of a company as defined by the Companies Law. I leave it open, but Companies Law of the DIFC.
Right, so it must be a DIFC.
Must be a DIFC company. Similarly, the regulatory law provides for a provision which is not included here, but is referred to in the rules. And again, that would be a company which is subject to the regulatory law, which has license to provide a financial service or financial product and is subject to the powers of the court and the FSA pursuant to the regulatory law. thirdly, the law of damages and remedies, and this is one which I would ask you to open at tab 3, provides, and this was relied upon in the submissions on behalf of the claimant in this case, at chapter 4, article 42, and over the page at 46. These powers are, by their terms, confined to the circumstance where the court is seeking to enforce a judgment or order. So it is a power for the opponent to receive a full execution, in the words of Article 46.
So it doesn't arise here.
And it doesn't arise here.
Yeah.
So the question then is there some equitable jurisdiction that may exist, because in our respect this mission there is no express power conferred by statute. And if I could start by referring you to the judgment that my friend submitted, the Derby and Weldon judgment. And in that case, the jurisdiction for the existence of a Morena type injunction, including at an interim stage, is considered by Lord Donaldson. And if I could refer you to page 76 in terms of that judgment.
Yeah.
The relevant provision at the bottom of the page is the Supreme Court Act of 1981, section 37.1 to 37.3, which is the successor of the original provisions of the Judicature Act.
Yeah.
And that provides in terms that the High Court may, by order, whether interlocutory or final, grant an injunction or appoint a receiver in all cases in which it appears to the court to be just and convenient to do so. So there we have the power of the court circumscribed by a widely framed statutory power and discretion in the court by reference to whether it is just and convenient. And that, admittedly wide power, forms the statutory basis for the existence of the equivalent power in the United Kingdom, and indeed in Ireland under the Courts of Justice Act 1924 being the successor to the Judicature Act of 1877, we have similar provision. So the circumstance here is that there is no express power in circumstances such as the present, it appears. And whether under the law, under DIFC law, whether there may be nonetheless a residual power by reference to English law to incorporate that power is probably an interesting question. And in my respect, the submission, while I don't say that these different statutory codes provide for a comprehensive self-contained code, as, for example, is considered in the case law in Forsyth and other cases of this court, nonetheless, there are express enumerated provisions providing for specific triggers of the appointment of a receiver, and it is not enough, in our respect for submission, to say, oh, there is a general power of the court, any more than it would be to say there is a general power of the court to award damages. You can't just come to court and say, you have a power to award damages, there must be a cause of action and a proof of loss that triggers that. Similarly, it may be that is an anomaly, but we make that submission.
Anyway, thank you for that.
There are two relevant provisions that I should nonetheless bring your attention to, not perhaps in my favour, but you might find support for the existence of a more general power without mentioning a receiver in Articles 36(1)(a) and Article 38 of the Law of Damages and Remedies, which provide for the general power of this court to grant an injunction, including at the introductory stage. But again, there is no reference in Claimant, despite there being quite an extensive list of other circumstances and powers and judicial powers that exist. There's no express provision.
Okay.
No mention of this. So that is that point. I'm happy to address you, should you wish, on the non-disclosure aspect. We've got a number of cases there. And also, there's one authority. We understand that the claimant has not made any case today for the existence of an implied term.
Not made any case of what?
Or for the existence of an implied term. In, for example, Article 2.4 of the...
that hasn't been any argument.
There's no arguments being addressed to that. There is obviously the Supreme Court judgment in the Marks and Spencer and BNP Paribas case, which you'll be familiar.
So far as non-disclosure is concerned, I don't need any help on the principles.
Yes.
I often find non-disclosure arguments and make waste.
Yes. And I think we mentioned that.
With, if I may say so, considerable justification.
Yes.
For present purposes, perhaps you could just tell me what you identify in as Ahmed's, or maybe it's your skeleton argument, as the most egregious form of
yes.
non-disclosure.
Thank you, my lord. I think it's...
It may be in relation to the criminal complaints, I don't know.
Yes.
Since I can't now remember what was disclosed.
I think I can. The first point, I think, is that irrespective of the argument as to whether or not the 3 million that was recouped was an unlawful act of self-help, as we say it, or the construction that the claimant is putting on it, that it was that he was entitled to do that, and it did not in some way amount to circumstances where he was back in control of the money. That the existence of those facts and those circumstances was not brought forthrightly to the
So, I'm not quite clear what you're saying was not brought to the court's attention.
The fact that the 3 million dirhams had actually been recouped by what we say were unlawful acts of self-help, but be that as it may, that was the position when the original application was being made, and we say that not sufficient highlighting of that crucial consideration was relevant, because if irrespective of whether we're right or the claimant is right, it is in relevant circumstances as to whether the claimant stands in an effective position of loss as of today. And certainly the case was presented at the interim non-notice, without notice stage, and again before you, on the basis that he stood at a very substantial loss in terms of the purchase price. So that's number one. Number two, as you will see from the chronology that's had been handed in and from our skeleton argument, there were a series of drastic steps taken against our clients before the Dubai courts. Some of them civil, some of them criminal. They commenced in March 2017. When the claimant came before this court in August, fully 6 months had passed. That campaign, the extent and identity of those proceedings...
So just forgive me, mislaid this chronology. Yeah, I have your number, yeah. You say that as from, well, Farmex started in March. But
in March.
But the defendant started, the claimant started in April and then through May.
Yes.
And June.
Yeah.
Okay.
And that speaks for itself. The position in terms of the jurisdiction of the Dubai courts, you have rightly highlighted. I've just mentioned that there is a provision of the contract law, the DIFC contract law, which specifically governs the obligations of parties in respect of checks. I think it's Article 70 or 77 contract law. And therefore, if the claimant had an entitlement to cash the checks, and if the claimant wanted to enforce that, having not succeeded in the encashment, he ought to have brought his remedy before this court, not before the Dubai courts.
Maybe it's not a question for you. The claimant filed a criminal complaint against the defendants for breach of trust. What was that about?
I think, as I understand it, that's how it's framed as a matter of against a guarantee check. That is the term of art in under commercial.
Okay, thank you. So it's part of the checks point.
Yes. The scale and the scope and number of those proceedings was not presented to the court at the time, and nor, as we have pointed out in our witness statement, have all those proceedings been withdrawn, notwithstanding the undertaking given to you on the last occasion. And there do exist extant civil and criminal proceedings, and you'll see from the exchange of affidavits on this point that the claimant's position, as I understand it, is effectively that those proceedings do not come within the scope of the undertaking. From my client's perspective, this is a matter of very, very serious import. They remain subject to the threat of penal sanction as a result of those proceedings. In addition, there are receivership proceedings in being over the company, and on my most recent submission, those receivership proceedings have not been withdrawn.
Just help me with one of the points you make is that these proceedings were instituted in mid-August, 3 months after the defendants regained control of the company. Now, the defendants, you say, gained control of the company when?
The 10th of May 2017. That was when the police were called. When Mr.
Oh, the time of the lockout.
Yes.
Yes.
And because my clients were on the trade license, the police said, look, that's the position as far as we're concerned, and that is what led to the effective physical control of the premises being secured.
Yeah, okay, right, that's right. Right, well, thank you very much. Any more? No, thank you very much.
Thank you.
Do you mind we have a short break, is that all right?
That's good for us.
I'll rise. Thanks.
All right.
Yes.
My Lord, in reply, I'm going to try and deal with points quite succinctly and not take too much of your time. But the question that the court will ask itself is who has the better argument with respect to whether or not the agreement has been terminated. And we submit that that's the appropriate question. If the court finds that we have the better argument, that the agreement is still live, and we can purchase these shares, whether or not we paid all the consideration, or whether or not we have to pay further consideration, but ultimately we have a right to these shares, then we have the better argument. If the court finds that the other side have the better argument, that actually the agreement's come to an end because they've accepted our repudiation, then the court should reject our first proposal in terms of the order that should be made. Before dealing directly with the pleadings of the defendants, there's a few factual points, and one of them, if I can ask you to turn to page bundle 3, page 671.
Did you say 671?
Yes, 671. There's actually two
Bundle
671.
2,
From bundle 3. Bundle 3, I believe. Oh, it's 2. Bundle 2.
Yeah.
There's actually a confusion here because actually there's two 671s, and the one I'm looking at is the second one in the bundle, and it's around page 680.
Is what you want?
That it's basically a picture of two checks. It's labelled 671 in my bundle.
I got 671.
And can you see two
some
checks?
suspend search, it's called.
No, so it's you have to flick further in the bundle, and then the numbering starts again after 695 and 696.
You want 696?
And after
Oh, I
696.
see. There's
Yes.
a duplicate page.
That's right.
So, what do you want? 671?
Yes.
The second 671?
Yes. And these are two checks, or the check.
Hang on.
Sorry.
I found. Yeah, I see a check. Yes, of course.
Yes.
Thank you.
So this is the £3 million being paid by the defendants into the Dubai court. This is that check. And the point that I was trying to make before, but this document I was confused because I couldn't find the second 671, was that you can see it's by order of RAG Foodstuff Trading.
Yeah.
You can see that in both the two documents, the actual check and then the information underneath.
Yeah.
And the point that the claimant says is he wasn't being paid for these security checks. Effectively, the money is coming out of RAG, the third defendant, which is the company which he had been running since execution of the agreement and had been investing substantial amounts into. This is where that payment comes from. And so what the claimant says is...
It's just money. It's just money.
But the money, he's saying...
It's not the same money.
It's not the same money. What he's saying is his own money. Effectively, what the defendants have done, instead of writing a check, a personal check, placing that money into the account, they put money into the account which belongs to the third defendant. And that's money that the third defendant says he's invested into the company and effectively getting money back from the company.
Well, I think that's common ground, yes. He's getting money back from the company.
That's right. But what he's not getting is the $3 million that he paid to the defendants. And therefore he doesn't accept that this is a refund of his money. It's a refund of money, but it's money from the company which he says he should be purchasing. And the point of confusion is that what the claimant is saying is he's paid $3 million. He's paid the initial $3 million, payments 1, 2, and 3. He also says he's paid 1.25 additional, and we looked at the Paul and Hassan report where that's referenced. But there are other amounts that he's invested into the company. If one looks at page 523.
Sorry?
523.
5 which three?
23.
2 million. So just staying with the 3 million.
Yes.
If this was the return of the 3 million that he paid under Article 2.1 and B, I mean that's where the money would have gone to RAG, wouldn't it?
That it would have gone to RAG. That's right.
Yeah.
But he,
so on one view, this is simply returning the money that he paid.
on one view, but
Yeah.
actually the confusion is that the security checks were made personally by the defendants. And the other issue is that what he says is he's put in lots of money into this company. Now, in response,
Anyway, sorry, for 6, what was the page again?
it's 523.
523.
523. 23.
I'm nearly there. I've got you.
And I'm looking at paragraph 142.
Yes.
And this is the witness statement of the first defendant. And paragraph 142 he says, in his witness statement, the claimant asserts that he injected capital of AED 6.8 million into the company. I confirm that as no audit of the company's accounts of 2016 has been prepared, I'm not in a position to confirm whether this capital was injected into the company. In any event, any injection of capital which remains an assertion does not constitute any consideration under the SPA. The claimant was managing the company at that time for his benefit and to the detriment of Minnie and I. And the point there is that there's no denial that significant amounts were being put into the company by the claimant. We also say it's surprising that the first defendant can't say whether or not money was put in, or at least the extent that money was put in. And on that basis, we say the claimant's evidence should be accepted that he's put a large amounts into the company. At page 909 of the bundle, which is
Another bundle, isn't it?
yes, bundle 3 now. So this is the witness statement of Mr. Saboowala. And what he says at 55, paragraph 55, at the foot of the page, in addition to paying AD 4.25 million, I'd collected receivables of 2015 worth approximately AD 12.3 million at my cost. This was deposited in the company's CBD account, which you'll recall was being handled by the first and second defendants. And the defendants were to use this to pay off the liabilities from 2015 and prior to this date. But instead of paying the liabilities, the defendants withdrew or transferred the funds to his other accounts, own accounts. This information is set out in the CBD account ledger attached. Now, if one looks at 953 and pages 954 as well, so page 953 and 954, this is a ledger referring to Magic Book Terra Transport LLC. Now, we saw that name in the Horwath report as being a related company, but you can see that what you have here is amounts going out on a regular basis, transferred. You can see the words transferred to MBT routinely down this page, and amounts going out. And you can see then at page 954 a figure of 12 million. And what Mr. Saboowala is saying is this amount's being taken by the first defendants into from the company, and they're helping themselves to that. And I point these out because what you were told by the defence is all a matter of contractual construction, and that's not actually the case. There is actually substantial agreement about what the contract entails. Number one, it entails, upon execution, certain assets and on payment of the first 3 payments, certain assets would be to be transferred. It entails the appointment of Mr. Saboowala as a manager to singly manage the company, and the appointment of a nominee to the bank account. What we say 2.4 means, and we say it has to mean this, it has to be the right of Mr. Saboowala, who's the purchaser, to be able to decide on seeing something untoward or something that's not satisfactory to the due diligence, to say whether or not he wishes to continue the agreement or effectively accept the repudiation. It's almost a mirror image of that concept. And he was entitled to say, I don't like the way that this is being run, but I think this company still has value to me, and I'm willing to make payment. He's also, we submit, entitled to say, the only audit that we have is the Horwath report. I think this is correct. I stand by this report. He also, regardless of that position that he took, which of course I'm not denying that he took that position, he did say, get the Paul and Hassan report. He did then, for several months, ask, where is this Paul and Hassan report? He did repeatedly say, let's sit down and agree the amount that I'm meant to pay. And then he took some missteps. And the question for the court is whether those missteps are enough to be repudiatory breaches and whether they've been accepted. Now, the way page 492 is the one finds the defence and the way that it's put.
492.
Yes. So that's at page tab 19.
Yeah, I have that.
And so that's what's appropriate is to look down this list. This is the way the claim has been put, the defence has been put. So the claimant acted in repudiatory breach of the agreement by inter alia retaining the security guarantee check in respect of the trademarks, following the assignment of the trademarks and refusing despite repeated requests to return the same. By their own admission, the defendants accept that the annexures ought to have stated the assets of the company, including the trademarks. Well, I'm hearing noises to that effect. We're saying that they should have done. And what is agreed is that no annexures were provided at the time of signing the agreement. And without the annexures, the claimant can't be blamed, or at least to an extent where his withholding, return of the cheque, is being counted as a repudiatory breach. He can't be blamed to that extent. They're saying, I'm not going to return this cheque. And also, he can't be blamed in circumstances where he has put millions of AED into the company and is worried about what's happening to those. Now, we were taken earlier to the law of contract, and there is, of course, an article which deals with set-off at Article 91. And I'm not going to go as far as to say that a right of set-off applies. But what I do say is that it's not unreasonable for the claimant to think, they owe me lots of money, they're taking money from this company, I'm entitled to that right of set-off, whether or not, as a matter of law, he was or wasn't. And the point being that his action can't be considered a repudiatory breach in that context. Then let's look at paragraph 115b, retaining the security guarantee check in respect of vehicles. Well, the point is, the actual SPA does not say vehicles. The other side, the defendants, say, well, that was the intention. But actually, they don't actually plead rectification. They just simply say that was the intention. Mr. Saboowala denies that that was the intention. And we say, at the very least, it was reasonable for him to abide by the plain language of the agreement. It can't be a repudiatory breach. Moreover, the defendants never transferred the vehicles. They accept that. And they say, well, we couldn't because we were told that they had to be in the name of the company. But what Mr. Saboowala says is there were loans on those vehicles, which the defendants ought to have paid off, because the vehicles were meant to be transferred free of loans, free of and mortgages, etc. But they weren't paid off. And that's why the vehicles weren't transferred. So even if the defendants are correct about the word vehicles, that should be substituted for the word share transfer, the vehicles were never transferred. So that can't be repudiatory. Next, acted in fundamental disregard of the due diligence process by unilaterally seeking to impose his valuation on the claimant and by refusing to engage with the defendants in good faith as required. And the question is here, what the claimant is being blamed for doing is for trying to rely on the audit report, the only audit report that was carried out, and that was in his possession. And we said that can't be a repudiatory breach, especially when we can see from the documents he was willing to meet, he was willing to allow Paul and Hassan to carry out their due diligence, and even today he's willing to pay money into court. Number D, 115D, acting in fundamental disregard of the termination and orderly exit provisions of the agreement. Well, it's unclear to us what that means, but we're told today it's 2.4. But as we say, 2.4 allows the claimant to decide whether or not he wants to walk away after receiving a bad due diligence, but he chose not to do that. So that can't be repudiatory. 115E, attempted to force completion on terms that did not reflect the agreed purchase price. And this is the point about 10.5 million. If I've understood my learned friends correctly, what they're saying is the purchase price has to be 10.5 and that's it. But that's not what the clauses say in the SPA. They refer, when the table at clause 2.1 refers to a deduction of any other outstanding payments liabilities owed by the company and the sellers, including but not limited to, and then there's a whole list. So it can include anything. And again, he engaged Crowe Horwath, professional auditors, and they came out with a figure. 115F, seeking to encash and taking steps to enforce the security guarantee checks when he knew he had no entitlement to do so. And as I said this morning, he shouldn't have done that. That was a mistake. He acted out of anger, perhaps, to recoup his losses, perhaps, and he shouldn't have done that. He should have come to the DIFC court. But what is absolutely clear, we say, is that in doing that, he was still trying to obtain the shares and obtain completion, because at the same time that he was making complaints about these checks, he had also issued, in the wrong court, admittedly, proceedings for an appointment of a receiver, which would only mean that he was trying to get the shares ultimately, and an appointment of an expert to work out exactly the consideration that should be payable. So he was doing the right thing in the wrong jurisdiction. And in normal circumstances, the other side, if a party applies to the English court, for example, they make an application, say you're in the wrong jurisdiction, the party then changes jurisdiction. And the way it happened here was the claimant comes to the DIFC and eventually gets advice that this is where he should be commencing proceedings. But again, that's not a repudiatory breach, especially in circumstances where, however we regard the level of aggressiveness of his actions in trying to cash the checks, the fact is those checks bounced and they were not backed by cash. And when one can't ignore that fact, nor can one ignore the fact that the money that was then paid into the account, into the bank, into the Dubai bank court account, didn't come from the personal property of the defendants, but in fact from the company. One can't ignore that. Paragraph 115G, commencing and prosecuting police complaints and criminal proceedings against the defendants for the purpose of forcing payment to him of monies. Now, firstly, there's an assumption there that that's what they were trying to do, force payment to him of monies. Perhaps, as we suggested earlier, he was simply trying to recover some of the many millions that he put into the company And again, it may have been foolhardy, overly aggressive. He may be right to criticise him for that. But again, it was always clear that he wasn't relying on clause 2.4 in that regard. The defendants themselves say he made no demand under that clause. He was simply taking what they say is misplaced self-help action. And that is not, we say, repudiatory. And at most, one would have a claim for money. And then 115H, engaging in conduct that was tantamount to an attempt to unlawfully expropriate the defendant's business. Well, we just say that's simply not the case. He's not trying to expropriate it. He's trying to pay the proper consideration based either on his estimate or on a figure that's correct and the court finds. Next, acting in fundamental disregard of his contractual and fiduciary obligations as temporary provisional manager of the business and in breach of trust contrary to the interests of the company and its shareholders. So this is now a company action being alleged. There's no particulars of this. It's all pie in the sky, we say, and should be totally ignored. J, enjoying the benefit of profits of the business to which he was not entitled. Well, number one, under the agreement, he would have been entitled to take the profits from the period of 1st of January 2016. But number two, what he says in his statement is he didn't take profits from the company during the time he was manager. He was basically building the business up and trying to make it thrive, something which he says the defendants failed to achieve. And then K, acting in competition with the company to the detriment of his business, in conflict with his solemn obligations under the SPA. Don't know what this refers to. This looks like breach of competition law or the like, and we say it's simply fanciful, which ties into the very last paragraph of this defence and counterclaim. But there's a whole list of allegations under innumerable legal heads of claim, from negligence to passing off. I'm looking at page 500. Breach of competition law, passing off, damages for infringement of trademarks, unlawful interference, negligence, breach of fiduciary duty, wrongful interference, harassment, malicious prosecution, abuse of process. One reads this list and asks, number one, where's the particulars for any of these things? But number two, which party is acting in bad faith? You know, we have one party, the claimant, who's made fundamental mistakes of procedure. We have other parties where what the evidence points to are sham transactions, taking money out of the company, handing over checks not backed by cash, failing to cooperate on due diligence, failing to sign checks in relation to suppliers, which damages the company, when under circumstances where the company were not being run for their benefit had the share purchase take place, and all manner of mistakes and bad behaviour. And yet they turn around and blame the claimant. And we say it's unfair and would be extremely unfair for the courts, number one, to overturn the order of Mr. Justice Field, which we say is correctly made, but also not to give relief to protect the position of the claimant, because this agreement remains on foot. And if the court cannot reach that decision, or say as much as that, it's certainly got the better argument in that regard. In terms of, so that's what we say in relation to the first proposition into the order that should be made. In relation to the receiver, you haven't been taken to RDC 25.1, and in particular 25.116. Do you have the...
Yes, I do. Thank you. Sorry,
25.116.
Yeah.
Which says the court may grant the following interim remedies in 16 years an order appointing a receiver or receiver and manager having such powers as the court may see fit of the property or any of the property of any body corporate. That's any body corporate, doesn't matter where it's situated. And my learned friend referred to other parts of the court law which grants the court wide discretion to make interim orders. And we say on that basis alone, the court does, of course, have the power to make any order which it sees fit, especially, or specifically in this context, the appointment of a receiver. And the receiver is also mentioned at 17 as well. we said the court rules, the court law, which you've taken to, would be wide enough as well to grant that jurisdiction. And I don't believe that actually my learned friends are saying that it's completely out of the question. Merely they've cast doubt on whether some of the legislation that's referred to as Part 49 of the RDC relates directly. But I don't believe they're saying that it's undoubtedly the case that you don't have jurisdiction. And we say it must be the case that you do have jurisdiction. In relation to the evidence that's before you, mention was made of 49.10. And we say that there is sufficient evidence that's been put before you in both submissions and in the witness statements and the attachments and exhibits to explain the reasons why the appointment is required. And the details of the property which is proposed that the receiver should deal with is also clear in this case. And therefore, we say the court has enough before it to make the order of a receiver. I said this morning that actually we would be happy with this, and we could understand a court taking a position, oh, this is all so messy and muddy, and there's allegations going both ways, and I don't need to decide on who's correct. But one thing is correct: there's a mess here that needs to be sorted out, and it would be useful for the court to have an independent officer of the court appointed over these assets to, number one, make sure that the position is held pending trial, and number two, to actually see what has gone on in this company and actually what has taken place. And we say that as a practical matter, it's certainly just and right for a court to make an order like that, and we would be satisfied with that order, despite the fact that we think we have the better argument in terms of whether the agreement remains on foot or not. My Lord, unless there's any further questions.
That's extremely helpful. Thank you. This is not entirely straightforward. What I'm going to try and do is give an oral judgment tomorrow at 2 o'clock. I'm afraid it's not the only thing on my plate. If for any reason that proves to be not practical, I will certainly tell the parties and do so, say at up to 12 or 1 o'clock, that I am going to have to provide reasons later, but I will say what order I'm proposing to make at that stage. Okay? Is that right? If 2 o'clock is inconvenient for you, please say so. If you prefer a different time, okay.
That's perfect.
Thank you very much indeed for both of you. Thank you.
All rise.